Hi everyone, this is lecture number 4, so we're going to start our tour of the North Carolina cases with this video. I'm going to take the cases 2 at a time, so there'll be 3 videos, each one covering 2 cases. Now let's remember we've talked about legal reasoning and precedent as reasoning by analogy. We've talked about how to brief a case, how to take notes on a case when you read it. What we're after here is some sense of what it's like to work within precedent, how legal reasoning works, what are its virtues, what are its defects in terms of this way of proceeding. And we'll step back after we're done and talk about this more generally, but let's dive in and see what it's like to be inside. So this exercise places you very much in the position of a first-year law student trying to make sense of materials that are really hard to make sense of. So let's acknowledge at the outset that you're going to be confused, you're not going to understand what's going on. The kind of reading required for this is different than what you're used to. You have to be very precise and careful. And I'm going to try to illustrate that as we go. So let me share screen and let's talk about the first 2 cases in this line of cases, State v. Pendergrass and Joyner v. Joyner. Okay, slideshow. Okay, so here we go. Background. Right, there are various forms of law. Constitutions, our law we have in the United States, a federal constitution, you all know, and all the states have constitutions, and those state the framework of government, entrench certain rights, talk about certain procedures and rules. The broadest sort of principles and framework of government in constitutions, statutes are laws made by legislative bodies. We'll run into a statute in one of the cases here. The people we elect make the law. They make the law about what crime is and what it isn't, and what's a contract and what's not a contract, and so on. A lot more law historically was made by judges from case to case, but now those bodies of law have been codified in laws that legislative bodies pass. Administrative regulations are more particular rules that the executive agencies write and promulgate and enforce to carry out laws made by the legislative body. So Congress might say, we'd like some clean air, but it falls to the Environmental Protection Agency to specify how we're going to do that. And then there's common law or case law, which is law made by judges. And that doesn't go away. So say you have a statute, Title VII of the Civil Rights Act. We're going to look at that later. No discrimination in employment based on sex. Okay, Congress passed that. But what did it mean? The courts have to work that out over time. So we're going to have a look at how judges interpret statutes. Criminal law versus civil law. Criminal law is all of us, the government, prosecuting somebody for crime. There'll be a punishment, fines or jail time often, and that's a form of law. Civil law is the law that governs relations between private parties mostly, but also between the government and individuals when we're not talking about a criminal matter. No one's going to jail. Somebody may owe someone money. Somebody may be told to do something, but it's not a penal matter. Substantive versus procedural law. Lawyers learn a lot about procedure, about the rules, about how you do things in courts and cognate institutions. Substantive bodies of law are bodies of law that deal with subject matter, right? The law of discrimination, family law in a given state, and so on. And precedent and stare decisis are key terms. They're slightly different. Precedent is some interpretation of the body of relevant materials. That's often contested, and there's often room for creativity, right? You could grab some idea or argument from some area that's not directly the area you're working in and make an analogy. Stare decisis is slightly different. It's the very strong norm that prior decisions are to be followed, right? It means roughly let the decision stand. And the last thing I need to say before we turn to the 2 cases here is these institutions of trial, judge, and jury, and the division of labor that's developed in the law over the last couple hundred years between law and fact. We're going to talk about the jury later at the end of the course. And it used to be that juries would be legal interpreters. They would be told that they got to interpret the law. Now we tend to think that the law is for the expert, the judge, and the jury is there, oddly, to say what the facts are. So the judge tells the jury the law, and the jury's job is to figure out the facts and apply the law to the facts. And this often involves, at the end of a trial, especially a criminal trial, a judge reading the instructions to the jury, and those are what the law is. And if you find X, then the law requires that you find Y as a common locution in this picture. All right, so long wind up. What's going on in State v. Pendergrass? Well, the first case is about a teacher who's prosecuted for assault and battery. Assault is the threat or attempt, and the battery is the accomplishment of the violence. Assault and battery for beating a student. And the student had bruises on the arms, bruises on and marks on the arms, and bruises about the head and neck. And the question in the case is, what are the legal limits on the teacher's authority to use physical force to punish, and why? So, I think I'll just, let me pull this up so we can take a look at it. And I'm sorry about the quality of this reproduction, but you can get a lot out of this first paragraph, and I'm just going to read it. All right, indictment for assault and battery. The offense consisted of whipping with a switch inflicted by defendant, the schoolmistress, upon one of her younger pupils. The switching left marks upon the body of the child, upon which were also found marks apparently made by some blunt or instrument. All of these marks, however, disappeared in a few days. Right. The nature of the charge to the jury appears from the opinion. Verdict was against defendant, who thereupon appealed. So right from there, we can see that there was a trial. The judge told the jury what the law was. We find out about that later in the opinion. And the defendant was convicted for this beating of assault and battery. So what does the court do with it? What's the court's analysis? Well, the court doesn't agree with that conclusion, doesn't agree with what the trial judge told the jury about the state of the law or the legal principles involved, right? The court begins with an analogy, and this is common in law, right? How should we think about this relationship of authority between teacher and student? Well, the court begins with parent and child. The parent is empowered to use violence against the child to correct the child, train the child. This is a world, obviously, where the adults can't really imagine a situation where adults don't hit children to make them behave or to teach them how to behave. And a parent can do that. The court begins with the analogy that the parent-child relationship is the way to think about this, and the teacher-student relationship is much like the parent and child relationship. So that's a move, right? That's what I said. We want to look at how courts go A, B, C, D, how they reason. If you see that move right off the bat, you can question it. And it's a common idea. There's a Latin locution for it in loco parentis. The teacher stands in for the parent and has much the same authority that the parent has over the child. Okay, so where does the court go from there? Well, okay, the parent has that authority, must have that authority. It's for the child's own good, right? Why does the law grant a parent or a teacher that authority to hit the student or the child? Well, you might have heard this in your own life. This is for your own good, or this is going to hurt me more than it's going to hurt you. When a parent said that to me, I kind of thought, no, it's going to hurt me more than it's going to hurt you, because you're going to be the one hitting me. But that's the idea. It's the welfare of the child. So you can see that in You can see that in the opinion where the grant of authority is discussed as for the child's own good. I'm just trying to find the welfare of the child up here. The welfare of the child is the main purpose for which pain is permitted to be inflicted. Okay, now from that proposition, the court spins out two limits, and this is the important part of the case. This two-prong test, this two-part test that states limits, is going to migrate to a different relationship, and that's the husband and wife relationship. And the bridge is going to be a divorce case, Joyner v. Joyner. What are the limits? Well, if the purpose of the violence is to help the child, then it wouldn't be consistent with the purpose to inflict permanent physical injury, right? Now, that's a limit, no permanent injury. If you cause permanent injury, it's per se over the line and illegal. We could, in theory, have to worry about what is or isn't permanent injury. We could, in theory, in a different time and place, not this time and place, bring in psychological harm or damage. That's going to come in later. That's not really part of their world. But we actually don't have to worry about that in the future cases. It never really comes up what is or isn't permanent injury, but it could. So that's one limit, no permanent injury. But there's also a second limit that the court wants to talk about, even though this teacher, they're going to find acted within her authority. She didn't cross the line. And that is that not a focus on the impact on the victim, but a focus on the consciousness or the mental state of the perpetrator, of the the one who punishes, and that has to do with intention. And I think that the legal term that just captures all of the different ways this is put in the cases is malicious intent. That is, even if permanent injury doesn't result, the person doing the punishing can't be acting maliciously or with malicious intent, or the way the court puts it here is to gratify her own bad passions. The idea that you sort of enjoy inflicting pain on someone else. That it's in good faith, and otherwise, like you might make a mistake, you might hit the wrong kid, you might you might get a little carried away, you might be a little excessive or disproportionate. That seems to have been the case here, obviously, but that's okay too, as long as you're in good faith, as long as you're trying to do your job and you're trying to use the violence for the purpose the power is given to you, which is for the child's own good. So there can't be malicious intent. So we get this two-pronged test: no permanent injury and no malicious intent. And if you don't have either of those, then the legal authority of the teacher has to be respected, even if the judgment might be questionable. The person is entitled to do the judging and make mistakes or be excessive, as long as they're in good faith and as long as they don't cause permanent injury. So let me make a couple of comments about this case before we move on to the next one. It's interesting in the writing, and I said last time that there's a kind of a performative element to judicial opinions. This one, you can see it. The court is actually sort of performing what it's saying. We don't get a lot of details about the infraction. What did the child do? We don't get any details about what the child did to bring on this beating. We don't see it from the child's point of view. We see it from the teacher's point of view, and we see a need to prop up and recognize and support the authority of the grown-up here, the teacher, to use the violence, right? At trial, it seems that the trial judge told the jury, look, your job is to find the facts, and the facts could be in dispute. The teacher could deny that she did it. But if you find that she did it and it resulted in these injuries, then the law draws the line there that she's guilty. So you find the facts, but I'm telling you that if these are the facts, then she committed assault and battery. And he must have been thinking something about disproportionality or severity, right? Like maybe it was a minor thing the kid did and the beating was severe, and maybe there'd be some kind of balancing proportionality approach, which opens up its own can of worms. But the jury found the teacher guilty. The court reverses, the teacher's not guilty because of these two limits. Okay. let's see where this idea goes, where these ideas go. So we're going to move on to second case. My animations are out of order here, so I'll just put them all up. So Joyner v. Joyner is not a criminal case. It's a civil case. So you can see it's Joyner against Joyner, Mrs. Joyner against Mr. Joyner. She's suing him for divorce, and her complaint, her paper that she files to start a divorce proceeding, um, says he hit me with a switch, and he hit me with a horsewhip, and he verbally abuses me, and I think I should have a divorce because, you know, I don't want to be hit with these weapons. Um, and the court is looking at this as a procedural issue. Um, the wife at trial has been given alimony. He has to pay her pending the trial and the outcome of the case. It's a funny little Latin term in there, pendente lite, pending litigation. Like lawyers love to say things in Latin. Why say it in English if you can say it in Latin? Because you look really smart. Um, and the court notes that the legislative body has passed a law that expands the basis or grounds for divorce, right? Divorce was a very difficult thing to have. Back then, you couldn't just say, oh, I don't like him anymore. You could say he's openly and notoriously having an adulterous affair with someone in town. That would be grounds for divorce. But, you know, here we bring in kind of maybe cruelty as a grounds. But the law itself that the legislative body passed said that when you file your papers, we've allowed more divorce. We're being generous. You can get out of the marriage, but you've got to say particularly and specially what's going on, right? So these are known as pleading requirements. What do you have to plead? What do you have to prove? Um, and the husband then is challenging the sufficiency of the claim, and it's a reasonable idea in law. You know, if you don't know a lot about the allegations against you, it's hard to defend against them. Basic idea in criminal law. So he's saying, you know, you've said I've hit you with a switch and a horsewhip, and I've abused you, but you haven't said when, you haven't said where, and you haven't given detail, right? So it's time, place, circumstances. And when you read this, you'll see that the court says, well, yeah, time and place are important, but they're not that important. We don't care about alleging the time or the place. You could show that at trial. It's not central. But interestingly, the circumstances become central. And basically, the argument is she didn't plead basically a negative proposition. And here we get introduced a very important idea in the subsequent cases, the idea of provocation. The court's argument is basically she didn't allege that she did not provoke him, right? And she didn't talk at all about why he hit her with the horsewhip or why he hit her with the switch, which is a very interesting way of looking at it. You know, you might think just the beatings themselves would be per se cruelty and grounds for divorce, but the implication is, it's kind of astounding to our ears and eyes, that if she had provoked him, he could be within his legal authority if he did hit her with these weapons. Maybe he just happened to have a horsewhip in his hand and she mouthed off and he hit her with the horsewhip, and that would be okay. It would be even justified, the court says. So her pleadings weren't sufficient because she didn't talk about the circumstances. And the court is very suspicious about whether she asked for it, right? And in fact, it writes a lot about the authority of the husband. So what's the idea of marriage that we see here? Well, it's a relationship of domination and subordination. It actually, the way the court writes this opinion, and you got to remember, obviously, North Carolina will be a different place in 10 years, for obvious reasons, a different government. But you know, the relationship is much like partakes of the central relationship of domination and subordination in the society, which is master and slave. It's not as harsh as master and slave. It's not as unlimited as master and slave, but it partakes of it. The wife must be subject to the husband. And to make her obey, he can use violence, and he can maybe even use a horsewhip and a switch. And the court quotes the book of Genesis on this, that it's you're going to be subject to him. Um, so there's a lot of rhetoric about how to think about that relationship and who gets the benefit of the doubt in these interactions. She actually has to say, I didn't provoke it. It was unprovoked. And if it was provoked, the implication is it would be fine. So that's a bridge in terms of ideas about marriage, in terms of ideas about the asymmetrical power relationship and how the court sort of, without, that's the world we're in back then. The court embraces that. So I'm going to stop this video here. And I'm sorry this went on longer than I had hoped, but the 4 cases you really have to be concerned with are all a bit different. Black, Rhodes, Oliver, Black, Rhodes, Mabry, Oliver. These next 4 cases are different in that they are state prosecutions of husbands for assault upon wives, and we look at the particular facts and reasoning in those cases. Okay, see you in a minute. Or a week, as the case may be.